Appellate jurisdiction. The power of a higher court to review decisions made by a lower court is strictly governed by statute. The foundational principle governing when an appeal can be heard is known as the final judgment rule. Generally, federal appellate courts, like the courts of appeals, cannot review a decision until the trial court has entered what is legally termed a final judgment. This means the trial court must have resolved all issues pertaining to all parties in the case. This rule is codified primarily in Title 28 of the United States Code, Section 1291. However, recognizing that waiting for finality can sometimes cause undue hardship, Congress and the courts have carved out specific exceptions allowing for what are called interlocutory appeals, appeals taken before the case is fully concluded in the trial court. Therefore, understanding appellate jurisdiction requires mastering two main pathways: the standard route via the final judgment rule under Section 1291, and the limited exceptions permitting review of non-final orders. Building directly on the statutory foundation of Title 28, Section 1291, we now examine the core requirement of the final judgment rule, absolute finality. This means an appellate court gains jurisdiction only when the district court has entered a judgment that resolves every single claim asserted by every single party involved in the litigation. If even one claim remains pending, the order is generally not final for appeal purposes. The rationale centers on judicial economy and efficiency. Allowing appeals piecemeal, reviewing decisions one by one as they occur, clogs the appellate dockets and risks having appellate courts waste time reviewing issues that might become moot later in the trial process. Furthermore, appellate courts need a complete factual and legal record to make an informed review. Think of the litigation process as building a tall stack of documents. Only when that entire stack is complete, sealed, and finalized can it be safely moved up to the appellate level for review. Any premature movement risks dropping the entire structure. So, what exactly constitutes this required, final judgment that unlocks appellate review? The core definition is straightforward. A judgment is final when the trial court has resolved all issues presented to it and has nothing left to do except execute the decree or order. Finality means the case is over in the district court. To illustrate this, let us contrast typical final rulings with those that are decidedly non-final. On the final side, you will see orders like a dismissal with prejudice, which permanently ends the case, or a judgment entered after a full trial on the merits where all claims have been adjudicated. These are appealable. Conversely, most orders issued during the litigation process are not final. Examples include routine discovery orders compelling document production, or the denial of a motion to amend pleadings. These rulings do not dispose of the entire case and must await the ultimate resolution before they can be challenged on appeal. The key takeaway is that the trial court must have completely washed its hands of the matter. We have established that the final judgment rule, codified in Section 1291, is the default gatekeeper for appellate review. While this rule promotes judicial economy by preventing piecemeal litigation, strict adherence can sometimes create significant problems. Imagine a situation where a district court makes a ruling on a critical, case-dispositive issue, perhaps denying immunity, that, if allowed to stand, renders the entire subsequent trial pointless, or causes irreparable harm. Waiting until the very end to appeal that single, crucial error forces parties to incur massive, unnecessary litigation costs, or worse, suffer irreversible consequences. This is where the law recognizes necessary exceptions. We must now pivot to the concept of interlocutory appeals. These are appeals taken before a final judgment has been entered. They represent carefully carved out exceptions, established either by specific statute or by established common law doctrine, designed to address these precise situations where waiting is simply too costly or unjust. This introduces the fundamental tension we must navigate, balancing the efficiency gained by avoiding fragmented appeals against the fairness required for litigants facing immediate, critical rulings. We now turn to the first major common law exception to the final judgment rule, the collateral order doctrine, often referred to simply as the collateral order doctrine. This doctrine was established by the Supreme Court in the landmark case of Cohen versus the Corporation of Presiding Bishops. The doctrine permits immediate appeal of a small class of orders that, while technically interlocutory, are considered sufficiently final for appellate review because waiting for a final judgment would render the appeal meaningless. To qualify under the collateral order doctrine, the district court order must satisfy three stringent requirements, which must all be met simultaneously. First, the order must constitute a conclusive determination of the disputed question. Second, the issue decided must be completely separate from the merits of the underlying action. It cannot be intertwined with the substance of the main claim. And third, the order must be effectively unreviewable on appeal from a final judgment. This means that any right asserted by the appellant would be lost forever if review had to await the end of the entire case. These three hurdles make the collateral order doctrine a narrow exception indeed. Having examined the common law exception provided by the collateral order doctrine, we now shift our focus to the statutory exceptions codified in Title 28, Section 1292. This section carves out specific instances where interlocutory review is permitted by law. We concentrate here on Section 1292, subsection A, paragraph 1, often cited as 28 U.S.C. Section 1292A1. This provision grants an immediate right to appeal any order of a district court that grants, refuses, or modifies an injunction. The critical feature distinguishing this statutory right from the collateral order doctrine is its nature. Review under Section 1292A is automatic upon the issuance of the order. There is no need for the court to certify the issue, nor does the appellant need to satisfy the three stringent prongs of the Cohen test. This mandatory right stands in sharp contrast to the discretionary review available under Section 1292b, which we will cover next, or the highly selective nature of the collateral order doctrine itself. We now turn to the final statutory exception we will discuss: permissive interlocutory appeal under Title 28, Section 1292, subsection B, commonly known as Section 1292b. This mechanism allows for immediate appeal of otherwise non-final orders, but crucially, it is entirely discretionary and requires affirmative action from the trial court. For an order to be appealable under Section 1292b, the district court judge must explicitly issue a certification order finding that three specific elements are present. First, the order must involve a controlling question of law. Second, there must be a substantial ground for difference of opinion regarding that question. And third, an immediate appeal must materially advance the ultimate termination of the litigation. If these three hurdles are cleared, the party seeking review must then petition the Court of Appeals, which retains its own discretion whether or not to accept the appeal. Remember this key procedural point: the district court judge must explicitly state in writing that the order meets these criteria and that immediate review is warranted. Without that explicit certification order, the appeal cannot proceed under this provision. We have just examined statutory exceptions, like Section 1292b, that allow immediate review of non-final orders. Now, we must address Federal Rule of Civil Procedure 54b, which is often confused with these true interlocutory appeals, but serves a fundamentally different purpose. Rule 54B is not an exception to the final judgment rule. Instead, it is a mechanism used by the district court to create a final judgment prematurely under Section 1291. This rule applies exclusively in cases involving multiple claims or multiple parties. If the court resolves one claim but others remain pending, the order is usually not final. However, Rule 54B permits the court, upon finding that there is no just reason for delay, to expressly direct entry of judgment as to that resolved claim. This certification transforms that specific ruling into a final, appealable order under the standard final judgment rule. It is a tool for managing complex litigation efficiency, not a deviation from the core principle of finality. Having clarified the role of Rule 54B, let us now synthesize the entire framework for appellate jurisdiction, which is always the very first question on the bar exam. The starting point is always the presumption. Is the order a final judgment under Section 1291? If the answer is yes, you have jurisdiction. If the answer is no, the order is generally not appealable immediately. You must then check for exceptions. First, look for the common law exception, the collateral order doctrine. Second, check the statutory exceptions under Section 1292A, specifically for injunctions. Third, consider the discretionary exception under Section 1292B, requiring district court certification. If none of these paths apply, jurisdiction is lacking, and you must wait for the final judgment. Remember, jurisdiction is the absolute first hurdle in any appeal.